Welcome to the dedication of the American Museum of Tort Law, which is the first museum of any kind in North America. There are 35,000 museums on almost every issue, but we're very pleased to break new ground here in a society that espouses the rule of law. It's only fitting that there be at least one museum dedicated to a very important pillar of our legal system, the law of wrongful injuries known as tort law, and the civil justice system that administers it. I want to welcome the guests and the speakers and thank the Methodist Church for providing this very nice space. The Museum of Tort Law was created to focus on the rich historical legacy of tort law in American life and culture, to inform people about the effect of tort law on their lives every day, and inspire a sense of future possibilities for the well-being of our society. The Museum of Tort Law strives to increase citizens' understanding of tort law because citizens are always told, when they're backed up against the wall by the law, that ignorance of the law is no excuse, and they're presumed to know the law. This museum is trying to fulfill that responsibility. There are many cases throughout history that have built the common law of torts to protect the physical integrity of human beings from violation to their health and safety. And the role of tort law plays an enormous function in protecting personal freedom and safety. Freedom was once defined by Marcus Cicero over 2,000 years ago as, quote, participation in power. And if you have the unfettered right to seek an attorney and go to a court of law for your grievance, that is participation in power, especially when you're judged on the facts by a jury of your peers, rooted in the Seventh Amendment of our Constitution, and before a judge who instructs the jury on the law. The process is extremely open. It's very well refereed, far better than legislative and executive branches, where people have to often pay or beg to get anything responsive to them. But when it comes to a court of law, it's direct democracy. The initiation is from a plaintiff who is gravely or wrongfully injured to the attorney, to the court of law. It's open to the press. It's subject to appeal. It has all kinds of internal checks and balances, cross-examination, the control of any wayward jury by a judge, and appellate review. You can't really do any better than that. And we are unique in the world in having a system of civil justice where you can have a contingent fee lawyer, you can be tried by a jury of your peers in open court with a verbatim transcript subject to appeal. It doesn't really get any better than that, but we have to increase the utilization of the civil justice system so that more people who are wrongfully injured can use it and generate deterrence against unsafe practices way beyond the range of the case throughout industry, and also beyond deterrence, achieve, of course, compensatory justice and hold perpetrators accountable, something that you'll hear a lot about in today's ceremonies. I think Learned Hand always puts it so concisely. At the museum, you'll see the basic quote by him. It says that if we're to preserve our democracy, we have to have one commandment, quote, thou shalt not ration justice, end quote. But he said something I thought even more profound that I picked up at law school. He said, and tort law is very, very connected with freedom, the freedom to defend yourself, to assert your rights. He said, quote, liberty lies in the hearts of men and women. When it dies there, no law, no court can save it. That's where its basic roots are. Not in our Constitution, not in our courts, not in our statutes. It's in the minds and hearts of the people who are the beneficiaries to uphold, protect, defend, expand, and utilize. I'd like to introduce our executive director, who is Rick Newman, who practiced civil justice law here in Connecticut for many years. He's a graduate at the University of Wisconsin, honor graduate, and he, among other achievements, he's a co-author of the treatise on Connecticut tort law, and he's also a specialist in the area of law and ethics. Mr. Newman.
Thank you. Thank you all. Thank you, Ralph. Thank you, Pastor Edens, for letting us use this beautiful room on this occasion. And I am truly honored to speak to you as the Executive Director of the American Museum of Tort Law. We are gathered here this morning to dedicate the American Museum of Tort Law, something that is unique in American history, the first museum in the nation wholly dedicated to law. And more than dedicate this museum, we are here to celebrate the twin foundations on which this museum rests. Tort law, that body of law which is truly of the people, by the people, and for the people. And second, the right to trial by jury, enshrined in the 7th Amendment to our Constitution, in the Bill of Rights. And the law works. Tort law, the law of wrongful injury, has grown and changed as society has grown and changed. It serves to compensate the injured, disclose acts of wrongdoers, and deter future wrongdoing. It serves to safeguard the health, safety, and welfare of our citizens. And trial by jury, of course, safeguards our freedom, access to court so that we can assert and protect and defend our rights to life, liberty, and the pursuit of happiness. And yet, as we all know, tort law has been under sustained attack by those who seek to ration justice, to limit access to the courts, and deprive citizens of their day in court. The museum aims to be a voice safeguarding tort law and the right to trial by jury. The many exhibits in the museum will educate and inform, and I hope will inspire the citizens who come to our museum or who read about our museum on the web. The museum will be much more than just the physical building that we invite you to see if you haven't already seen next door. The AMTL, as I have taken to calling it, will have an active web presence with significant legal developments, legislative developments, and other matters that will help the public and practitioners and scholars alike to be educated and informed. The museum will serve as a national center for scholarship, research, and symposia. We are and will continue to be actively looking for cases of significance to serve as a repository for legal papers and materials, documents, physical exhibits themselves, so that we can become an archive for this important body of law. As our funding grows, we will create traveling exhibits and take the museum around the country to the people. And ultimately, I hope the museum will become a national voice for tort law and trial lawyers and civil justice and trial by jury. It is an important undertaking, a unique undertaking, and an audacious vision, which we begin here today at this, the dedication of the American Museum of Tort Law. Thank you. None of my juries ever did that. At this point, it gives me great pleasure to introduce Carl Mayer. He is one of the members of the board of directors for the museum, he's overeducated. He holds a master's in law from Harvard, a law degree from the University of Chicago, and went to Princeton as an undergraduate. He clerked for United States District Judge Caleb Wright, is a former law professor, and has served as special counsel to the New York State Attorney General. He dedicates his law practice, writing, and electoral efforts to ending the tyranny of corporate power over American citizens, and has worked with or represented the Sierra Club, Friends of the Earth, the Animal Legal Defense Fund, and the Humane Society. Ladies and gentlemen, Carl Mayer.
Thank you very much. One of the, in my judgment, most important and enduring works of fiction of the 19th century was the play written by Henrik Ibsen, The Enemy of the People. You may recall that the central character in Ibsen's play is a Dr. Stockman, who is a good Norwegian burgher, lives in a prominent family in a Norwegian town. The town has hitched its future and its welfare to the construction of a municipal bath, a health and wellness bath. And Dr. Stockman has one problem, however, is that his conscience is bothering him. His conscience is bothering him because he has a sense that the baths of the town are somehow polluted. And that is causing sickness and illness in the community, particularly amongst the children. So what Dr. Stockman does, as a central character of the play, is he goes and he has the water of the health and wellness baths tested. And it turns out that there are these tanneries that are located near the baths, and some other commercial interests are leaching pollutants into the bath of the town. So he does two things. First, he seeks the truth, and second, he wants to pursue justice. And he's convinced that in an effort to pursue justice, what he needs to do is simply tell the people about this and organize a campaign to stop the pollution of the baths of the town. You know, in modern parlance, we would say this is a tort of public nuisance, right? This is a pollution by private commercial interests of the foundation of the town. The newspapers do not want to hear about it and try to persuade him not to engage in this, not to publicize this. The mayor of the town refuses to help. And of course, by the end of the play, he is considered, what the title of the play is, he is considered an enemy of the people. And too often, those who seek truth and seek to advocate for justice are characterized by those who are the wrongdoers and those who are the powers that be, as they say, as enemies of the people. And it's, to me, a great irony of this age that the wrongdoers in our society, in this, Ibsen's words echo across the ages. It's an irony of this age that the wrongdoers in society create a climate where people who seek the truth and pursue justice are characterized in the public perception as enemies of the people. And it's, to me, this play encapsulates everything about the fight for modern justice, and it encapsulates everything about how the tort system is critical to ensuring that the safety and well-being of the population takes precedence over the narrow commercial interests of the few. So everything in Ibsen's play, everything is turned upside down, and in the decades-long assault on trial lawyers, everything gets turned upside down. So I think one of the reasons we're here today is to remedy that. This museum very specifically and boldly and rationally lays out all the important landmarks in the law of protecting the citizens when private actors do not respect the laws of our country. Now, I was supposed to introduce former Attorney General Ramsey Clark, who could not be with us today, but I want to say a couple words about Attorney General Clark, because he is someone who embodies a lawyer who seeks truth and justice and practices in that vein. And he is a model, particularly for the younger people in the audience. As Attorney General of the United States, and this might be very hard for younger people to believe, as Attorney General of the United States under Lyndon Johnson, he not only drafted and helped pass the Voting Rights Act of '65 and the Civil Rights Act of '68, but as Attorney General, he denounced police shootings and he authorized the prosecution of police on charges of brutality. He went further and he opposed electronic surveillance of the American citizenry. And he refused to authorize an FBI wiretap of Martin Luther King. And he fought hard against the death penalty and he won. And he even put a stay for quite a considerable period of time on federal executions. It's been a long time since a national attorney general has advocated and taken action for the citizenry, rather than so often we see attorney generals refuse to prosecute wrongdoers while in office, and then after being attorney general go and work for the law firms and very corporations that, as attorney general, they have declined to prosecute. One case in particular that Ramsey Clark was involved in that sort of captured my imagination, partly because he serves as an example of someone who is in public office, but then after being in public office continues to pursue justice rather than takes the customary role in corporate America or in a law firm. Many of Attorney General Clark's cases were controversial, but mostly because he had a poll star principle, which is to represent anyone in a criminal proceeding regardless of political persuasion. So he's received some criticism for some of his representations, but his fixed principle that people are entitled to right by counsel and representation stands as a steadfast commitment to justice, which too often the opponents of trial lawyers, public interest lawyers, they try to sweep that under the rug. They try to sweep under the rug the fact that there are so many lawyers working for justice in this country. And Ramsey Clark, I think, stands as a stellar example. One of the cases he did that just captured my imagination was when he left the Attorney General's office, he defended Father Philip Berrigan, the anti-war activist, and a group of Catholic priests and nuns who were known as the Harrisburg Seven. They were indicted by the United States Attorney for the Middle District of Pennsylvania in 1971. They were indicted because, as part of a surveillance program of the Nixon administration, there were certain political activists were targeted. It seems kind of quaint, given that now virtually everyone is surveilled by the Justice Department under the administration of both parties. Well, anyway, back in the quaint old days, the surveillance was targeted on Father Berrigan and these Catholic nuns and priests. And somehow there was an exchange of letters that suggested that they were discussing kidnapping the the head of the National Security Agency, none other than Henry Kissinger. So Ramsey Clark took the case and in a brilliant defense, he simply stood up and said, "My clients are committed to justice and always will be," and sat down. Because he felt it was too risky to put before the jury the fact that some of these Catholic nuns and priests had burned draft cards. They were acquitted. They were acquitted eventually on appeal on all charges. I couldn't help, though, but being captivated by this notion that somehow these Catholic nuns and priests, a cohort of them, were somehow going to take Henry Kissinger and kidnap him. And I didn't know, I couldn't really know what they would do with him. It's been very hard since I read about the case. I'm imagining that they were going to alight across the country in a Volkswagen van with a peace sign on it, and put Kissinger in bell bottoms and John Lennon glasses, and maybe take him to a monastery and have him listen to Gregorian chants one day. And I thought maybe another day they would take Kissinger and they would take Kissinger maybe to a university and have him write on the blackboard, I will not make war anymore, 5,000 times. I will not make war anymore. But I wanted to end on a serious note. So often in society, the Henry Kissingers of the world receive the accolades and the recognition. He receives an accolade of the Nobel Peace Prize, even though, as documented in William Shawcross's magisterial book, he was responsible for 2 illegal and unauthorized war campaigns in Laos and Cambodia. So the world is turned on its head. And again, the words of Ibsen echo through the centuries. The Ramsey Clarks of the world, the Ralph Naders of the world, the Louis Brandeises of the world, the people who fight to represent the powerless, the infirm, the poor, those who need justice, they do not get the accolades. And I hope that the Tort Museum will be a small corrective to that unfortunate chapter in American history. Thank you.
Thank you, Carl. It is my great honor to introduce Senator Richard Blumenthal, the senior senator from our home state of Connecticut. Senator Blumenthal is well known to and greatly appreciated by us. He served an unprecedented 5 terms as Connecticut's Attorney General, and his aggressive law enforcement for consumer protection, for environmental stewardship, for labor rights, and personal privacy has helped reshape the role of a state attorneys general nationwide. He was a key player in the fight against big tobacco, which is in the museum, helped bring to an end the deceptive marketing of tobacco products aimed at kids. In 2014, he introduced the Hide No Harm Act. This is a bill which would make it a crime for a corporate officer to knowingly conceal the fact that a corporate action or product poses a danger of death or serious physical injury to consumers and workers. He has also served as a United States Attorney for Connecticut and in the House of Representatives and the State Senate. He served as administrative assistant to Senator Abraham Ribicoff and a law clerk to Supreme Court Justice Harry Blackmun, and served in the United States Marine Corps Reserve. Ladies and gentlemen, it is my great honor to introduce Senator Richard Blumenthal.
Thank you. Thank you. Thank you very much. I'm really honored and very excited to be here with this very, very eminent gathering today, folks from all over New England and the East Coast. I'm reminded of this story you've probably heard about Jack Kennedy when he welcomed the Nobel laureates from America to the White House for dinner, and he said that this was the most distinguished gathering in the White House since Thomas Jefferson dined alone. And I think this is the most illustrious gathering of consumer advocates and trial lawyers since Ralph Nader prayed alone in this church. I don't know whether you ever prayed in this church, Ralph, but It is an occasion not only to dedicate a museum, but really to give thanks and pay tribute to one of the historic consumer advocates, but public citizens of our time. And so, Ralph, thanks to you for giving us the model of much of what we do. Before I was a legislator, before I was a prosecutor, before I was state attorney general, and before I was a senator, I was a trial lawyer. And I owe to my fellow trial lawyers much of what I do today, much of the abilities. My former partners as a trial lawyer, one of them is here today, Rick Silver, who, along with many of you, does the real work of vindicating rights, making rights real in American society. We are dedicating a museum that celebrates the big cases, the cases that come to prominence because they attract media attention. But day in and day out, trial lawyers go to court, they do depositions, they interview witnesses, they try cases, and they take risks. They take risks with their reputations, with their financial situation. They go to court because they believe they can do justice. And making rights real requires trial lawyers and public advocates and consumer activists that, at the end of the day, make the justice system work. It is a system composed of human beings, therefore it's fallible. Juries make mistakes, so do judges, but it depends on the advocates being willing to put themselves on the line, to encourage their clients, to encourage those who are wronged to come forward. Often it will take courage if they're victims of police brutality or sexual assault to come forward. And we celebrate today not only the rule of law in an abstract sense, torts, which is a body of that law, but also the public advocates, the private attorneys general, who come forward and have that courage and strength to make rights real. We also recognize, I think today, that those rights are imperiled. And so too our justice system is imperiled. You look at what's happening today in the place I work, in Congress, where the efforts toward mandatory arbitration, increasing the costs of access to the courts, the threat that there will be, in effect, penalties for bringing cases to the courts, making the loser pay, so-called tort reform. Well, my hope is that this museum will not only educate the public, but also inspire young people to become involved in the justice system, because justice, like democracy, is not a spectator sport. And what we need to recognize is that sometimes the tort system and even our civil justice system fails to fully protect the public, fails to deter wrongdoing. That's the reason that I've introduced and sought to pass the Hide No Harm bill. Because all too often, as corporations grow bigger and more powerful and better financed, they can regard the financial costs imposed on them, and sometimes even the injunctive relief, as simply the cost of doing business. The cost of doing business for a company the size of GM is measured in hundreds of millions of dollars. To the public, that's a huge sum. But to GM, it may mean a lot less than the threat of criminal accountability. That's why I think our tort system needs to be supplemented by robust criminal penalties. or people who disregard the rights of ordinary people who are harmed by defective cars or drugs, people whose privacy is invaded, people who are victims of motor vehicle defects, all of the wrongdoing that our tort system tries to penalize but also deter. So my hope is that we will see this museum as part of the vanguard of moving our society forward, educating the public as to their stake in the justice system, mobilizing the public to support laws that protect them even more effectively, and making sure that the duty of care — how many times have we heard jury instructions about the duty of care? Something morally at the core of what our society should be, that the duty of care is something that is truly enforced and made real through the advocates who are here today, the many, many, many advocates, private attorneys general and trial lawyers across the country who vindicate rights every day, and the leaders like yourselves who can help us advance the law and make it even more real in the lives of ordinary Americans. Thank you so much for your great work, for your supporting this museum, for contributing to it, and again, my heartfelt thanks to our great hero, Ralph Nader, for all you've done. Thank you, Ralph.
Thank you very much, Senator Blumenthal. I was really lucky to have our state represented by Senator Blumenthal. Our state is called the Constitution State, and his work is very much reflective of constitutional rights and responsibilities. I just mentioned earlier, before we started this proceeding, that a lot of the good senators and representatives, when they take a stand, they're not supported by organized people around the country, and they're swarmed over by corporate lobbyists. So public education, enlightenment, participation, the idea of serving on juries, the only duty required in our Constitution in the midst of a lot of Bill of Rights, is very important to support people who stand tall in Capitol Hill and other state legislatures. I'd like to introduce Dean Alexa Shabakov from Harvard Law School, my alma mater. I do pay my alumni dues once in a while in person at Harvard Law School. They don't particularly enjoy often what I say, but I've always thought that Harvard Law School has never reached its potential. And my last address there was titled, "How the Mighty Harvard Law School Can Galvanize New Systems of Justice in America." And I look forward to a dialogue with the people who run the law school on that. Alexa Shabakov has a difficult job there. She has for years been in charge of trying to encourage law school graduates to be public interest lawyers, and not just lawyers in government or legal services, whose creation we can thank one of the people in the audience here, Edgar Kahn, and his wife Jean, who went to Yale Law School, developed the concept for Legal Services Corporation and got it through Congress. But she is also trying to get the debt burden lightened with funded fellowships and loan forgiveness, which at Harvard is some of the best of any law school in the country. And she also wants the more vintage career of public interest law, such as Public Citizen and others have pioneered. There's a lot of things you can say. She practiced law for the poor and deprived people, but she's a real fixture at Harvard Law School. And while some of them may want her to go away, she's not going away. And here she is, Alexa Shabakov.
Good morning. So I am not one of the people who is upset when Ralph comes to speak at Harvard Law School. In fact, I feel like we are pulling on the same side. But when Ralph asked me to come talk to represent his alma mater here today, I told him that I was not a torts expert and that instead he needed a torts professor. Fortunately, I will be followed by an August torts professor. Ralph said that I could talk about public service and social justice instead, and that I can do. And it seemed like a very fitting topic to speak about at the dedication of a museum created by one of the founding parents of the public interest law movement. Without Ralph Nader, there would be no public interest law movement. He really created a paradigm shift in how people think about the law and created the field with a few others of public interest law. So thank you, Ralph, for my job. Ralph has not been content to sue big industry and start a network of public interest organizations. As he also just alluded to, every year he comes to Harvard Law School and talks about the fact that Harvard produces primarily lawyers who focus their lives on representing corporate interests. In fact, a few weeks ago, he was at Harvard Law School. I got there a little late and could only get in because I pulled rank. The room was standing room only in one of our biggest rooms, and people had to be turned away. And although we have made great strides in supporting public service and social justice at Harvard Law School, Ralph mentioned a couple of things. We have the best loan repayment program in the country. My office has grown from 2 people to over 8 people. We have guaranteed summer funding for any student who wants to go into public service work over the summer, and typically send between 300 and 500 people into public service internships during the summer. Ralph's not wrong, of course, about Harvard Law School. When I got to Harvard over 20 years ago, there were only about 2 to 4% of the graduates going to public service work, either immediately or after a clerkship. And that number has grown a great deal. It's now at about 15 to 20% going into public service work. There are some who go into academia, either they continue their education or they teach, but the vast majority go into large law firms where they represent corporations. And by the way, when I talk about the 15 to 20% who go into public service work, I'm including the many private public interest and plaintiffs firms that many of you work at. We have worked really hard to promote that as a place where students can do social justice work. But still, the number seems to have stagnated. This is not a uniquely Harvard Law School problem. It's partially, I believe, about the structure of legal education. So, for example, recently my office helped organize, we actually were the main organizers, but had a number of co-sponsors, a series on lawyering for social justice with lawyers from a variety of law schools. And they all critiqued legal education for a number of reasons, including forgetting to bring real-world issues into the classroom and for teaching people to see the shades of gray so much that they forget about their deeply held values. And beyond legal education, it's also about the structure of the legal profession. Laws, as you probably don't need to be told, do not often serve the poor and the people without power. And there are just not enough lawyers to help those communities. I don't need to tell you, probably, that there is a big access to justice problem. You read a lot about the glut of lawyers, but there aren't enough spots for the lawyers who want to serve communities and help the underserved because there just isn't enough money going into the organizations. What I see starkly from my seat at Harvard Law School is that there are many idealistic and talented law students who would love to make a difference with their law degrees, but there are many barriers to entry for them. It's not just the pay differential, although that's huge. The big corporate law firms, as you may know, are paying $160,000. Public interest organizations may start about 45 or 50. And it's not just loans, which are huge. It's not unusual these days to see students graduate with $150,000 to over $200,000 in debt. But it's more than that. There are not enough entry-level jobs outside of large corporate law firms. And the pressures on those big corporate law firms to be more financially efficient recently means that pro bono still has not achieved the amount of support that we had hoped for, and is in fact in many places declining. I run a fellowship program at Harvard Law School that awards $45,000 stipends to graduating 3Ls and judicial law clerks to work for 1 year at a nonprofit or government agency. Even with the pay differentials, the debt, we had to waitlist 11 people last year who applied for these fellowships. We also give seed grants to students or graduates to start their own nonprofits as a way of trying to create new social justice mechanisms. And in fact, I see Jason Adkins, who is chair of Public Citizen, is on my selection committee here. And we had to turn away applicants for those seed grants, even though even the public interest lawyers applying for those seed grants would have likely have taken a pay cut to take our seed grants. I tell you all this to illustrate the need for mechanisms to help our young people pursue social justice work. And I'm hoping that the museum will be part of the inspiration and education to help these students hold on to their values and pursue social justice work. But I also wanted to end with a plug. If you are in a position to support public interest organizations and enable them to hire young lawyers, please do so. If you yourself run a nonprofit office, a government agency, a public interest or plaintiff's firm, hire a young lawyer right out of law school so they don't have to go somewhere they don't want to go. And send me your job postings. You may be supporting a future Ralph Nader if you do so. Thank you.
Thank you very much, Alexa Shabakoff. I always think of her work as helping young law school graduates get the kind of positions, whether it's individual clients or systemic justice, where they can take their conscience to work. You know, lawyers are almost entirely put in a position as secondary human beings, reflecting their clients, and in the corporate area, they may be considered indentured human beings. But the idea of going to work with clients that are conforming with your conscience, I think that's really what the great contribution is. And you don't have no idea how tenacious she is in that environment up there. It's my pleasure now to introduce a classmate of mine from Harvard Law School, Professor Joseph A. Page, longtime professor at the Georgetown Law Center in Washington, just recently retired into another phase of his activity. And Professor Page is the person who selected these cases in the museum, decided what had to go in terms of precedential cases, cases of significance. It's not an easy job. There's a plethora of choices, and have them weave a pattern of understanding so that you just stand out alone. I traveled in parts of South America when we were a lot younger with Joe Page. He's fluent in Spanish and Portuguese, and he's also written books on South America. Excuse me. I think the best general book on Brazil has been written in our generation, as well as a book on Eva Perón and the politics of Argentina. He is humbled to a point, so take what he says and reflect on it in terms of the broader significance of what he has done. And we really owe him a tremendous debt of thanks. I always say it's his duty, but once in a while you have to thank somebody for what he's done. And you can see it with the brilliant museum designers, Eisterhold Associates, and Jerry Eisterhold is here today, and the Maltby group that fabricated it. This is a real breakthrough in museum design. One of the reasons why there are no law museums, perhaps anywhere in the world, is it's extremely hard to provide visualization in an internet age of the cases. You can, have parchment under glass, but that doesn't work with most people under 50 these days. And so you're seeing a real design breakthrough, and I hope some of the press will focus on a design breakthrough. But what good is a design breakthrough if it doesn't have the substance? So this is not art over function or function over art. This is the blending of the two, and the genesis of it was Professor Joe Page working very closely with John Richard and others to make it happen. So your floor, Professor Page.
Ralph, thanks very, very much for that wonderful introduction. I only wish that my mother had been here to listen to it. She would have believed every word of it. It's been a long road. Sometimes it's been steep, sometimes it's been rocky, but the end of the road is just on the other side of this building, and it's a wonderful feeling to see this idea that came into being more than 15 years ago, a reality. A reality to commemorate tort law, a reality to commemorate the common law of torts, the law of torts that is made by judges. It's a law that has evolved over time. The tort law is dynamic. I've taught tort law for 51 years, and you see some amazing changes over that time. And one of the features of tort law is its ability to adapt itself to new challenges. And we've tried to present some of that in the Tort Museum, but you can sit here reading newspapers and try to think about tort law in the future and the challenges that it's going to face in the future. And I can just point out one particular challenge, which I'm sure will eventually be incorporated into the Tort Museum. And that is the challenge that will be posed by driverless cars. We have been reading about these technological breakthroughs that are about to happen. And when they do happen, they're going to create, along with benefits, a certain number of risks. And it will, tort law eventually will be faced with the challenge of deciding how to allocate those risks. For example, individual technology, in particular automobiles, might turn out to be defective, causing accidents. Or there may be problems in the interactions between the driverless cars and cars operated by human beings. Or hackers may hack into the systems of driverless cars and create who knows what kinds of havoc on the highways. So, this is something that's going to happen over the next 15, 20 years, and tort law will be part of the conversation about how you deal with the risks that are going to result from this technology. Of course, tort law is not going to be left in and of itself to deal with the problems. It's going to have to be part of a process that would include legislative action, or possible legislative action on both of the federal and the state level, administrative actions, possibly, even criminal statutes. So tort law is part of this process. And it's a part of the process that allows, up to a certain degree, the common people, the people to participate in making decisions about how risks are allocated. Now, of course, the jurors don't get to decide every question. There are two levels involved here. One is the level by which common law rules and principles are made, and that's mostly by common law judges sitting in the states. Can also be affected by statutes on the federal and state level. As legal principles are developed to deal with allocation of these risks. Once the legal principles and rules have been developed, they're applied in individual cases, and that's where the jurors come in, because they get to look at facts of individual cases and apply the legal rules to those cases and come out with results. So this is something that will eventually be, and I'm sure will eventually be, in the Tort Museum. Looking ahead, looking backward a little bit about the tort stories that we hear about. We've tried to put a number of tort stories in the museum itself, but the thing is that you're always learning about them. You're hearing about new ones, and I've got to take a minute or two to tell you about one that I just heard about or saw on a transoceanic flight on Monday. That explains why I'm still a little jet lagged. A transoceanic flight, flipping through the channels, and I came upon this movie. It was called Big Eyes. I don't know if anybody's seen Big Eyes, but it's a motion picture dealing with the phenomenon in the late 1950s and early 1960s of paintings of little girls with large eyes that became very, very popular and very, very lucrative for the artist who painted them. Except that he didn't paint them. As it turned out, he was merely the promoter. The person who painted all those pictures, hundreds and hundreds of them that sold all over the world, was his wife, who meekly went along with all this until she finally couldn't go on with it anymore, and so she came out after she separated from him and said, I'm the one who painted these pictures. He didn't paint the pictures. He got very angry and gave a story to USA Today saying that that he had painted the pictures and that she had a screw loose or something, and so what did she do? She resorted to the tort system. She brought a lawsuit in the federal court in Honolulu, alleging that he had slandered her by saying to the reporter that she had not painted these pictures and that she had a screw loose, and that his conduct had also inflicted emotional distress on her. And it all went to trial before a jury in an actual tort case, slander and intentional infliction of mental distress in Honolulu. And what happened in the case, which is, by the way, all of this is depicted in the movie, what happened in the case was that the trial judge decided that there was one way to settle it, and so he had them both sitting down in the courtroom, and he gave them both the paint and easels, and he said, "Okay, paint me one of these kids with the big eyes." And so she sat there and churned out a wonderful little portrait of a little girl with big eyes, and he sat there and sat there and sat there, and finally, when he raised his arm to paint, he said, "Oh, my shoulder!" And he pulled. I can't do it, Your Honor. I can't do it. I just did something to my shoulder. The jury believed her and came in with a verdict of several $1 million, which was upheld on appeal. Now, this guy was was a fraud and a crook, and he didn't have any money, so she's not going to collect any money on this. And she said she didn't go in this for the money. She went in it to vindicate her reputation and to get the credit that was due her in painting these pictures. Now, some people would say they're so kitschy. Why would anyone want credit for painting them? But it was her work that she'd been doing for all of these years, and she was proud of it. And she got vindicated. She was vindicated by tort law, by the tort system. And as I watched this movie, and then later on I consulted that great oracle, Mr. Gould, to look a little bit at the background of the case, I discovered that her name's Margaret Keane, and she's still alive. She's like 87 years old. She's living, I believe it's in Honolulu, and in her living room, hanging on the wall, is the painting that she painted in the courtroom. So there's our challenge, is to get in touch with Margaret Keane and borrow that painting and hang it next door. So thank you very much. I'm really delighted to see so many people here, so many friends. I'm really delighted at how the museum people took all our ideas and just made something really wonderful about it. And I hope that it has the effect, that the educational effect that we hope it will have, mostly, I would think, among non-lawyers and citizens to understand what the tort system is, what it has done, and what it can do. Thanks very much.
Thank you, Joe. As Joe's often said about tort law, better a fence at the top of the mountain than an ambulance at the bottom of the valley. And the prevention function, deterrence function of tort law is very important. I hope that if and when the Democrats control the Senate, Senator Blumenthal will have a key committee, and I hope he will have generic hearings on the massive attack by raw power, by corporate stratagems, by government impunity on the rule of law. The law is under massive attack internationally, domestically, constitutionally. We all know that. And at the same time, it's under attack. The court budgets are being shrunken. The trial lawyers are being slandered. The victims are being disregarded or treated with enormous arrogance against their plight and their day in court. Just this last week, ALEC, which is the notorious organization of corporatist state legislatures backed by money such as from the Koch brothers, issued a ranking of the 50 states under tort law. And the states that got the highest award and the highest grade were the states that had the most savage obstructions against the most vulnerable people who were wrongfully injured and want their day in court, against the people who, through no fault of their own, became paraplegics, came down with cancer, came down with lethal respiratory ailments, had their properties destroyed, no fault of their own, to have their day in court. And here you have a cluster of state legislators who have the nerve to rank the states that passed the most restrictive obstacles against these innocent and vulnerable people. Now, they would never do that. They would never dare do that in the area of civil rights. They would never dare do that in the area of civil liberties, even if the corporations don't like those kinds of laws. Partly because the plaintiffs bring cases against state action more often in those two areas of civil rights and civil liberties. But it tells us something that they dare to do it in a system of law that comes from the mother country and was embedded in our Constitution. That was part of the reason for the revolt of 1776 against King George III. And that was built up by judges of all backgrounds in all states Thousands and thousands of cases, expanding the tort of law to reflect rising community values. Awards for pain and suffering were not always allowed. Punitive damages were not always allowed. Demonstrative evidence in court was often outlawed. And as Dean Roscoe Pound of Harvard Law School once said, quote, "The law must be stable, yet it cannot stand still," end quote. And here's the tort law that has to confront now the new challenges, as Joe Page said, of driverless cars, but of artificial intelligence, of nanotechnology, of biotechnology, three of the most tumultuous technologies in the history of the world, apart from weapons development. So tumultuous that Bill Joy, the chief scientist at Microsoft, wrote an article 15 years ago in Wired magazine responding to these new technologies with the title of his article, "The Future Doesn't Need Us." The tort system has to be robust in order to embrace those perils, to foresee and forestall. And I really hope that a Senate committee will have open hearings in these areas so that we can get a more generic understanding of what is at stake here. And I know in working with our colleagues to build this American Museum of Tort Law, the question that haunted us was, where are the lawyers? Where are the 1 million plus licensed lawyers to set aside some time from their being attorneys for clients and hold up their role as officers of the court? They're all officers of the court, quasi-official people, to look out for the larger issues of the administration of justice in our country. And some of the lawyers have stepped up to help make this institution possible. Some of the lawyers have stepped up to take impossible cases of great importance and make them possible. But that's not enough. The plaintiffs are the real heroes in the civil justice system. They step forward. They risk calumny. They risk ridicule, no matter how grievous their injuries. They're the real heroes. And there are far more plaintiffs than there are lawyers to take their case. We only have to look at the critical studies of the Harvard School of Public Health, 2,000 dead Americans every week on the average from hospital malpractice. OSHA tells us over 1,000 Americans die every week from workplace-related injuries or toxics. And the Centers for Disease Control tell us, astoundingly, that 200 to 250 people a day die from hospital-induced infections. Not the ones they brought, the ones they picked up. And we have other forms of trauma and disease, most of which we'd like to think are preventable. Most of which we'd like to think the law will intervene between the perpetrator and the victim, between the corporation and the worker consumer, between the powerful and the powerless, between the wronged and the wrongdoer. So we have a very low utilization rate of all the laws that protect people. Very low utilization rate. And our job as lawyers, apart from being attorneys, is to grab hold of this wonderful but fragile system of law and give it the substance and the political support and the public education support and the bold practitioner support to protect it from the erosions of corporatism working through the executive and legislative branches at the federal and state level. I know you have a lot to do in the Senate, Senator Blumenthal, but this is one task I hope You will undertake, you're uniquely qualified to undertake it. But I cannot overestimate the crisis of the law in our country today. When I was a law student back in little old Harvard, I never dreamed we would be at this state in terms of the powers of the presidency, the shattering of the separation of powers, the expansion of empire, the domination of Wall Street over Main Street, and the exclusion of what it's all about, the utilization of the rule of law by the American people. And I'll end with a little bit of humor, although it's really not funny. I remember being at Harvard Law School, and they acculturated you with law school humor, which is a real strange genre. And so one day we heard a professor say, with a little swing in his voice, he said, at Harvard Law School, we distort the law of contracts in the morning, and we contract the law of torts in the afternoon. And we were supposed to chuckle accordingly. Little did we know that 50 years later, that's exactly what's happened. The law of fine print contracts are cannibalizing and destroying the law of torts. Compulsory arbitration, Senator Blumenthal, is only one of the ways. Unilateral modification, waiver of liability, waiver of trial by jury in the printed contract, with all these corporations and these corporate lawyers scheming to develop a society where corporate supremacy dominates all. And I think that's our task. As Senator Daniel Webster once said from Massachusetts, when he wasn't working for the National Bank, he put it very well. He said, quote, "Justice is the great work of man on earth," unquote. There is no liberty and there is no freedom without justice. And we thank you, Rick Newman, and others who made this institution open. We thank you very much for being here. I think Senator Blumenthal put it just right. There are a lot of savvy people here, a lot of experienced people here who are going to fan out, go back to where they work and live, and elevate our mission. Make sure that the legal profession connects with the people back home, and make sure that our legal profession, beset by so much raw power and powerful forces of disintegration, make sure that as a profession we have a high estimate of our own significance so we can convey that to the American people so they can have a high estimate of their own significance in life. Thank you all.
Wonderful. Thank you. I'm going to just make a closing announcement about. That was great. Ralph Nader, ladies and gentlemen.